number 28, Hewitt versus Palmer Veterinary Clinic. We'll wait until council leaves the table. Just a moment.
Good morning, Your Honors. My name is Mark Schneider, and I represent the plaintiff appellant Marcia Hewitt. In this case...
Counsel, may I interrupt? Would you care to reserve rebuttal time?
I'm sorry?
Would you care to reserve
yes,
rebuttal?
2 minutes, please.
Yes.
Thank you. In this case, the Third Department held that Palmer Veterinary Clinic cannot be liable for its own negligence in causing the dog attack on my client, Mrs. Hewitt. It held that the only claim against the property owner is for strict liability. In 1984, in Strunk versus Zoltansky, this court held that a property owner, a landlord, is required to use due care to prevent dog attacks on their property. This court held that a landlord is not strictly liable for a dog bite on their property, even if they had prior knowledge of the dog's vicious propensity. Rather, the Strunk court held the landowner is only liable if their negligence causes the dog bite. Now, Strunk is still the law of New York State, even though all four appellate divisions have now held a property owner who does not own the dog is only liable in strict liability. But there's no reason to change the established laws set forth in Strunk. I have found no cases where a property owner was held strictly liable merely because he knew of the vicious propensity of the animal that caused the injury on their property without further negligence.
So what about the anomaly that the dog owner may not be held liable, right, under the existing rule?
Yeah, that is
but the property owner may.
Well, that's an exception to the rule under Bard that every other property owner has to use due care to prevent a foreseeable injury. And because the state favors dog ownership and the dog owner knows their animal, they have made a very narrow exception for an owner of a dog once they know their dog has vicious propensities or even dangerous propensities. It's a propensity...
You know, the state favors property ownership too.
I'm sorry?
The state favors property ownership too. There are many protections for property owners, real property owners.
Well, not in this case. We have the long-established law of negligence, and the purpose of negligence is to make sure that the tortfeasor pays for damage they cause. It's to deter further negligent conduct and to ensure that the victim, the person bitten, gets paid for their injury.
Let me ask you this. If this, you're correct, and there is a negligence case permitted to be pursued against the vet clinic here, the landowner or the premises owner, or maybe he rents it, I don't know. Could he then ask on the verdict sheet to have an allocation made vis-a-vis the dog owner here, because this is one of those cases where the owner and the landowner or the premises owner are not the same.
Yeah.
Even if that party is not present in the lawsuit, because here, for example,
Sure.
I think she was discharged in bankruptcy.
You could, under the apportionment law, if that person was legally liable, and there are cases where unless you fail in process to get that person joined, they're still liable. But here, the owner of the dog is not a tortfeasor. She's not liable at all because as the owner, she would have had to know the dog had vicious propensities. So there is nobody to allocate with. And in any event, I believe...
Let me ask you a question, just so I'm clear on your claim. Your claim is simply before us as a comparative negligence claim. You aren't arguing strict liability.
Yeah, I'm not arguing strict liability because I think it would be hard to prove, but I think there could
I just
be.
want to get the
Yes.
procedural posture correct. I understand your rationale.
Yes.
Your procedural posture, I'm right. You're asking us to say this is a comparative negligence situation.
Well, not comparative negligence.
No.
My client is not negligent at all. It's negligence against the person who knew there was a foreseeable risk and failed to take due care to prevent it. And the vet in this case was the only person who had the ability to protect my client, because as a vet, they knew that a dog coming out of surgery with no anesthesia could be in pain. They knew that you're supposed to snug down the collar.
But are you arguing that, that you should be allowed to assert both strict liability and negligence causes of action?
No, no, I think. Well, you know,
that a plaintiff.
It's interesting, because under Strunk, if the vet knew the dog had vicious propensities, then we would have to prove further negligence. So with the landlord, the foreseeable risk is they know the dog is vicious. And then further, they have to do something to prevent it. Like
So actually, it's in some ways, it's a more difficult standard to meet.
negligence.
It seems to me that the difference is with strict liability, you have to show that you do have the vicious propensities. But once you do that, it doesn't matter what due care you take to prevent it. If you know it,
Yes.
then you're liable. Whereas the negligence requires, arguably,
Yeah.
either that you know of the vicious propensities or you do something else, and you don't use due care. Do you agree with me on that?
Yeah, absolutely.
Okay.
That's what Strunk says.
And in this situation, would you agree with me that, we talk about making a duty to act as a reasonable person to keep the property in a reasonably safe condition. As a veterinary clinic, would it be enough to require that all dogs be on leashes at all times and all cats be in carriers, and that owners generally control their animals?
Yeah.
That would be enough.
Yeah, I mean, otherwise, if you had vets only liable in strict liability, they could know that the dog was vicious. Many vets probably treat vicious dogs, and if that dog broke out of a cage and did even though the vet was reasonable, if he broke out of an exam room and attacked somebody, they would be strictly liable. And I have not found a single case where any court has ever said that for a property owner. It would be, strict liability would mean if you know your neighbor's dog is vicious and the dog comes on your property and bites somebody, you are strictly liable, even though you didn't do you used reasonable care.
Yeah, so that's what I just want to clarify, based on something Judge Stein was asking you about. Although strict liability does relieve the proponent of that theory from proving some other aspects of traditional negligence elements, nevertheless, it is a difficult standard to satisfy, is it not? Because of the intent requirement, just in your example there.
No, strict liability is the lowest standard. Once you have knowledge, even if you do everything right, you are liable.
But that's what I'm talking about, that
Yes.
burden itself. The burden you just described
Is
not
very
an
low.
easy one necessarily to satisfy. That's why a lot of dog owners don't necessarily end up being strictly liable.
Yeah, strict liability is the lowest standard, and negligence is a much more difficult standard.
No, I understand that there
Yes.
are more elements. I'm not disagreeing with you about that.
Okay.
In terms of the actual proof of that intent.
Yeah. And, the problem was on the dog case of strict liability based on knowledge is everybody denies knowledge. And you end up having to use private detectives and people. And what's vicious, is a dog barking and jumping vicious, or does it have to bite somebody? So I think this is a very clear.
So just so I'm clear, I know what the rule is. You're asking the court to say that the rule in Collier's, all right, in Collier, where the owner's liability is determined solely on the basis of strict liability and the vicious propensity rule, you're saying that that rule should not apply here, number one, because it's not an owner.
Yes.
And number two, that the normal restatement rule of ordinary negligence should be used the way Judge Klein outlined it. No,
Yeah.
I'm sorry,
Yeah,
Judge Stein.
and it always has until.
No,
Yes.
is that what you're asking
Yes.
the court to do?
Yes.
Thank you, counsel. Counsel?
Yes, thank you, Your Honor. May it please the court, my name is Judith Alman, Burke, Scholar, and Hurd for defendant respondent in this matter. Quite frankly, what plaintiff's appellant is advocating for is an unworkable standard. When you're addressing animals...
Well, why isn't it workable to just say that the rule with respect to owners of animals is limited to those owners? It doesn't go beyond that category of potential defendants, and that traditional rules otherwise apply to everyone else.
Because when you're
What's unworkable about that?
Because when you're talking about the traditional rules of negligence for premises owners, it's a foreseeable risk. So it's the puddle on the floor of aisle 6 of the Price Chopper. Everyone can look at that puddle and agree that if someone walks by that,
If my nephew brings his dog to my house, and I know that that dog is a snapper and nips at the heels of little children, I have no responsibility when somebody brings their kid in?
No, because you've just described vicious propensity. You've just described a dog that is known to you to snap at children.
So your rule would be that even the reasonable, you can start taking away some of those facts from that hypothetical. So your rule would be that as part of negligence as the landowner, you have to know that there are vicious propensities?
Respectfully, that's what the courts have held so far. In terms of the cases of claps
But I don't understand what's unworkable about where you were going. You haven't explained to me what's unworkable. It seems to me you wanted to argue it's because of this requirement of foreseeability. Courts and juries make those decisions all the time. What's unworkable?
Thank you for letting me come back to this point. Your Honor, just to your point quickly, I'd refer you to the cases of Claps and Christian that were decided by the Second Department in 2008 and 2006. And they're in our briefs as well. And Your Honor, to come back to your point in terms of what's unworkable, I'd refer you to the words of your esteemed colleague, Justice Abdul Salam, and her concurrence in Doar, who explained when you've got a baseball and you throw a baseball, you may not know exactly where it's going, but the laws of physics apply, and you can have an understanding of what is foreseeable of what's going to happen. You cannot do that with a dog. You
That
could
sounds
line
like,
up.
that sounds like a fact question, right? That is it reasonable for a vet who puts a dog through the procedure the vanilla went through to foresee that the dog might react in a way that would injure somebody? And would it be reasonable to have the dog restrained or to not have other people in the room when the dog is just, those are fact questions.
Well, first of all, I'd submit to you that the dog was properly restrained.
That's a fact question,
But
right?
other than that, Your Honor, what I would say to this point as well is that you could have 20 different dogs go through the same procedure and cannot say with any level of predictability or foreseeability how each dog is going to respond.
Doesn't that sound exactly like what your expert ought to say at a trial? Because how do we know that what you just said is true?
Well,
You see, what your argument has done, I think, is, from a jurisprudence point of view, is created a state of confusion. And the perfect example of the state of confusion, I think, that the court suffers from is Hastings versus Solvay. That's the loose cow in the road case.
Certainly.
You guys are familiar with it.
Certainly.
Usually I have to think of the fact pattern to remember the case, and this is a loose cow in the road case. And that case, of course, cut back a little bit on the Bard rule and said that a suit for negligence was allowed when a farm animal has been allowed to stray from property where kept, because it's something that a farm owner should know what they got to do. That's the same argument that for ordinary negligence here. And See, and Judge Abdus Salam's concurrence was very thoughtful. And I know because I wrote the dissent in that case, and it was always challenging to disagree with Judge Abdus Salam. But I did because the confusion that's been created by the application of inconsistent rules creates a situation where neither the parties, the insurance carriers, the injured person, no one knows what exactly the rules are and when a specific fact pattern can result in a difference. Now, this would be, I think, a minor change, not a sea change, because it deals with a non-owner of an animal. But it does seem more rational than us carving out particular exceptions to the barred rule as we did in Hastings.
So respectfully, Your Honor, I would disagree with you on this point and say that it is not a confusing standard because it is one standard when it pertains to domestic animals.
This is the only state in the country that has such a rule. Is that fair?
New York has had a rich tradition of...
It is the only state in the country that has such a Kafka-esque series of rules that govern liability for the acts of animals.
Doesn't it also present some public policy problems? For example, if we just focus on this case and this veterinarian with a strict liability rule, what veterinarian is ever going to want to treat an animal that the veterinarian knows to have vicious propensities if there's nothing that that veterinarian can do that is going to make them not responsible if the animal hurts somebody else? It doesn't make sense to me.
Well, respectfully, I would turn that question on its head. If instead the court is going to apply negligence and a due care standard, then what veterinarian is going to treat any dog? Because at any point, any dog, without warning, might bite or attack
Well, how
someone.
about keeping dogs dogs on leashes, on short leashes, or muzzled, or, there are any number of things that are pretty simple, I would think, for a veterinarian clinic to say, these are the rules of our clinic. If you don't do this, then you can't come in.
So let me give you...
Frankly, when I'm taking a dog to the vet, they sometimes have other exits where you can, or other entries, exits that you can take the animal through if indeed there is a concern, or after an operation, not usually walking through the main area. You're walking through some other area with the pet, or there's some downtime. So the veterinary medicine is actually much more advanced than I think you're suggesting, knowing how to deal with the kinds of concerns about how to not only protect everyone who's in the space, but the animals themselves. And as Judge Wilson has said, those raise perhaps questions of fact.
But again, I come back to the problem here in terms of dealing with dogs specifically. It's the issue of foreseeability. And that, I think, really is the issue here, because if you have these rules in place, as was in place in this case, and you have an attack by a dog, you would hold this veterinarian potentially liable and let the dog owner who said, this is an anomaly, this never happened previously, get away with it.
That's incorrect. What would happen is you would say, did the veterinarian act as a reasonably responsible veterinarian in its procedures that it used, just like it was outlined by Judge Stein? What's going to happen is everybody, got a lot of dog owners up here. All of our dogs are going to come, sure, all of us. And what's going to happen is when you take your dog in for surgery, when they come out of surgery, they're all going to have some kind of a muzzle on when they're brought out. And that's going to be the standard procedure. That seems like a perfectly reasonable response. And if a vet takes those reasonable reactions, or reasonable actions, then he's not in a situation where he's subject to liability.
So then if I may please switch then in terms of part of where this appeal is and part of what the motion was, that even if this court is to apply a negligence standard to this fact-specific pattern, we do not have someone who failed to exercise reasonable care and reasonable duty in this matter.
Well, why isn't there a question of fact about that?
Because the only information that appellant has offered in opposition is an expert affidavit that's based on a singular affidavit and case notes. The affidavit from the plaintiff herself is self-serving. He does not look at any of the 10-plus depositions that were done in this case, and the case notes are devoid of any reference of any aggressive behavior of this dog whatsoever.
So what you're saying is there wasn't notice?
Correct. Even if this court is
Right, and
going
without
to-
notice is not foreseeability, and so there wasn't a duty that existed. We understand that argument, but that doesn't mitigate against creation of an ordinary negligence rule. What it means is that you just apply those rules just as you outlined them.
So
And you don't need to say, we don't need to go to strict liability to apply those ordinary negligence rules.
I believe the court understands my position in terms of why strict liability and vicious propensity should continue as to dog owners and non-dog owners, so I will table that and address in terms of the negligence standard. If that is the direction of this court, it is the wrong case to do it for, because at the end of the day, it's still the defendant respondent who prevails in this particular case, because there is no evidence that plaintiff has submitted that there was any deviation from a standard, that there was any foreseeable risk, that there was anything that the defendant did to put itself in a position of liability, even under a negligence standard. So should this court decide that it does want to take up the issue of drawing this delineation between pet owners and non-pet owners, I submit to you this is not the case to do it.
Thank you, counsel.
Thank you.
Counsel?
Yeah, and I respectfully disagree. I think this is the perfect case. We have an affidavit.
Counsel, I'm sorry, and I'll let you do your marshaling of proof, but to get to the type of case this is, and to go back to Judge Feynman's hypothetical, if we adopt this rule in this case, there's no dog owner here, so we would be adopting a homeowner or vet rule. And in Judge Feynman's hypothetical, neighbor comes over with the dog. The dog owner and the homeowner don't know enough to get you a vicious propensity, strict liability, but it's close. The dog owner, under this new rule, would be off because it's strict or nothing. But the homeowner who took this dog in on a visit would have to show they took reasonable steps, otherwise they're liable under a negligence theory. What's the logic in that?
That gets back to Strunk again.
But that was an out-of-possession landlord,
But it's still similar, that first you have to show the foreseeability of a risk. And so if
But
the
I know those things that almost make this dog vicious, but not enough to give the dog owner strict liability. So
If it's-
dog owner, see you, I'm gone. Homeowner, what steps did I take? Did I try to muzzle the dog? Did I have it in a pen? Did I not let people come over? What's fair about that
If there's
scheme?
not enough for strict liability against the dog owner, I don't think there's enough for negligence
But
against the
isn't that,
property
as
owner.
we've been saying, a question of fact?
Right.
And then the owner of the home will have to come in and defend against what I'm sure will be your list, like your list of things you didn't do.
But wouldn't there be that same question of fact as far as the dog owner was concerned then?
I'm sorry, I didn't
Wouldn't there
understand.
be the same question of fact
Sure.
as to the vicious propensity as far as the
Yes.
dog
No.
owner? So if there's no question of fact there, then there should be no question of fact.
That's
as to
not
that.
correct in my hypothetical. In my hypothetical, you know this dog is somewhat dangerous, not vicious, not under our vicious propensity standard, but you have reason to know this might happen.
I think that then,
It could never, then it would never be possible to not meet, you'd always need to show vicious propensity for a landowner to be liable under your rule.
I don't see that happening where a dog does not meet the vicious propensity test for the owner, but then could rise to the level of foreseeability. Because foreseeability is part of the strict liability test.
So you would need both a vicious propensity and then you didn't take the reasonable steps to address it.
Yeah, you know, let's say.
That I thought was not your rule before.
Yeah, so I'm a little confused now too, because you're not, is whether or not the dog has vicious propensity part of the test for establishing notice to the homeowner or premises owner, Or is it merely just a factor to be considered in establishing notice?
Well, I could see another situation. Let's say your female dog is in heat, and there's a male dog just hanging outside your house for a couple of days, and you do nothing about it. You don't know this dog. It came from across town and is sitting there at your steps leading to your porch. And then a little kid walks up the steps and the dog bites him. I think that could be foreseeability. If you do nothing, if you see that your dog's in heat and there's another dog there panting and being eager, and it bites somebody. But
For
as
the
far
homeowner, that would be liability, but not under our rule now for the dog owner.
Right, that's right. So I think, it's like any negligence. You're going to have experts, what's foreseeable, what isn't. You're going to have
So
fact
then
patterns.
Is your point that really the concern implied or expressed in Judge Garcia's questioning is inherent to the tort regime that we have? That is to say that when an injury occurs, there may be the kinds of cases where society has already determined, the courts have already determined, that indeed someone or some company or more than one will be strictly liable for that injury, but others may only be liable if they fit within the ordinary negligence rules.
Yes.
That is inherent in the tort system that we have adopted it
Yes.
in New York,
Yeah.
through the country.
Yes.
And so the question is here, whether or not, as I see it, the question is whether or not you have premises owner liability, which we've understand. We know what it is, it's well established. And then we have this rule regarding the liability of a dog, of a pet owner, of an animal owner, and whether or not one cedes to the other.
Yeah.
What makes sense in the case.
Yes.
Yeah,
there's
the first step is either, was there actual or constructive notice? I'm sorry, Judge. And it seems to me that question is the beginning of the ordinary negligence regime. And that's different than vicious propensity rule.
Well, and notice is of an existing, the puddle
No, I
on the
understand what notice
floor under the watermelons. But this is whether it's foreseeable to a veterinarian that a dog that didn't have anesthesia, that had to be held down, that had a loose leash and came out next to a cat and was walking around panting and acting aggressive, whether that's foreseeable, it could cause damage. And I say yes, but also more important is Dr. Dodman, our esteemed expert, explained why that's dangerous and why veterinarians shouldn't do it. And in fact, if you do decide that negligence applies, I think that you should find that summary judgment should be granted to my client on negligence. I had a very well thought out affidavit based on the uncontested facts. Whether it's based on an affidavit or depositions, it's uncontested what happened. We have the veterinarian's notes that the dog had a nail pulled out without anesthesia. We have in the veterinarian's own deposition, they didn't snug down the collar, and it's uncontested that the dog was walking around in an agitated state before it escaped by slipping its collar. So I think that, and they opposed it with Dr. Palmer saying he thought it was reasonable. That does not meet the standard for an affidavit to defeat summary judgment. So I'd ask this court to find that Palmer is
Let's say we
liable.
agree with you on the standard. Why not just send it back to make a determination with the correct understanding of the proper standard on the summary judgment for plaintiff?
I'm sorry, I didn't catch that, Judge.
Okay. Let's say we agree with you on the standard, or the
Yeah.
legal standard. Ordinary rules of negligence apply under these facts. Why not send it back and let the court then decide how to rule on a summary judgment for plaintiff, given the correct legal standard, as the court articulates it.
Well, because once you have that standard, as a matter of law, we have established foreseeability, and they didn't use due care. What's there to decide? There is no expert, nobody besides Dr. Palmer said, no, we didn't do anything wrong. That's the extent of his affidavit. And I also wanted to address the issue of malpractice versus negligence, that Judge Ellis found that the ineffective anesthesia and the post-surgery procedure sounded in veterinary malpractice. And that's just wrong, because malpractice is you malpractice on the patient, not on a third party. And in our complaint, we stated all the facts that give rise to negligence, and we brought it in negligence. So it's unreasonable to say that the defendant was surprised that we wanted to proceed on negligence. If you look at the complaint, that was stated in there. And one last thing, just on apportionment, I think there's a non-delegable duty. The veterinarian cannot delegate to his human clients the right to restrain a dog in this situation.
Thank you, counsel.
Thank you.